believe the system would produce if we were just dealing with efficiencies. And so that's my hesitation.
I quite agree that the system will not produce that improvement if we are just dealing with efficiencies. I also question whether the proposed reforms would even touch the sides of moving that dial down from 6 years. I think the ambition is to see this start to come down a bit. So,
well, I want to emphasise, I do think it's important to emphasise that if we take this new CCBD division of the Crown Court, and they are dealing with, say, possession of a Class B drug, they are dealing with shoplifting, they are dealing with the ownership of a dangerous dog type case, they are dealing with those cases by a single judge, and Sir Brian's estimate that means the system would be 20% faster, then effectively, once you've taken those cases out, the rape case that goes to trial is speeded up. And that is the significance of the proposal.
The proposal reduces half of 3%. Jean, I'm sure it will, I think it will significantly increase the speed of those trials, but we're talking about half of 3% of the total criminal backlog. So my question is, if we want to really move the dial on that 6 years, what do we need to do? And are we going to do it?
No, I'm confident that if we're increasing sitting days to the end of this Parliament, and it's my intention to do that, if we are increasing investment in our courts and in our maintenance, and I hope to continue to do that, if we are implementing these reforms, that after the next election, we will be into a much better horizon for victims right across the board.
Thank you, Chair. Thank you for your answer so far, Lord Chancellor. I just want to come back to this issue of the impact assessment and the 20%. So what I wanted to ask about is just will it transparently show not just the assumptions, as you said in response to your question from Dr. Shastri-Hurst, but also the evidence and the analysis underpinning that figure? And in particular, will it list all of the factors which it is said would save time, so jury empanelment and deliberations, and also list those things which would add time, so things like the judge having to write their judgment, which they don't currently have to do in a criminal case, so that we can get a sense of what really underpins it?
Yes, it will.
And so, in terms of the impact assessment, I mean, how much will it show? How much of the backlog reduction will come from restricting jury trial as opposed to other measures like increased sitting days?
We will endeavour to do that.
Will it show the sitting days that are saved as a result of restricting jury trials in sitting days?
We will endeavour to do that.
Brilliant. I just want to ask about the Concord Act, which you touched on earlier. Your letter said that we may need 139,000 sitting days by 2030 to meet demand. Is the barrier to sitting 139 days physical, that is not enough courtrooms or judges, or financial? And if you had the money, could you actually physically sit those days?
We haven't got the judges, the courts, the barristers to sit to that. Obviously, that is an estimate of where we would be if we did nothing. But the system could actually not be that hot at this time.
And in terms of what the 1% of cases that is being retained by the Magistrates Court, it's particularly important that you have a right of appeal that is effective. I just wanted to ask about the legal aid position and whether there would be any resource uplift from the legal aid agency to fund the proposed appeals, because as a lawyer I know that reading through a transcript, applying the law to the facts, drafting the grounds of appeal, all takes time, and I just wondered whether the LAA will be providing funding for that.
Well, as we're introducing a new permission stage, of course I will look at the legal aid available to make sure that people are properly represented.
I just wanted to ask about the proportion of resources. It may be that it's in the papers and I haven't picked it up, but I mean, what proportion of the total criminal court's budget is used up by the 1.5% of cases that will lose jury trial in actual money terms? Because I know we've talked about numbers of cases, and some people have said, well, obviously it's a small number to justify such a drastic reform, but what does that look like in actual pounds, and how could any savings be redeployed to cut the backlog in other ways?
Can I come back to you on that? I haven't got that figure available to me.
And then the last thing I wanted to ask about is diversity, and that's something that
Yes.
I don't need to lecture you on. What specific mechanisms will there be to monitor disproportionate impacts on minority groups, conviction rates, sentence lengths, all disaggregated by race and other protected characteristics, so we can see the impact of these changes on all criminal trials, so that we can make sure there is no the problems that you identified in your report around racial bias in the justice system are not magnified, because you know very well that the conviction rates at magistrates court level are quite a bit higher than those before jury.
Well, thank you, Mr. Vaughan, for asking that question. And can I be crystal clear that there will be, in the event of implementation, the undertaking and the commitment to ensure that all data is published, so that the full scrutiny of the effect of these changes in relation to different ethnic groups is fully understood. I would want to emphasise that centering victims means it is important that we recognise that if you're black, for example, you're 13 times more likely to be a victim of crime than if you're white. 43% more likely, by the way, if you come from a mixed ethnic background. And if you're black, you're 4 times more likely to be a victim of homicide compared to white victims. For all of those reasons, as Ms. Russell was indicating, it's important that we recognise that black, Asian and minority ethnic people are also victims and want to see the system speeding up. If your son has sadly been murdered following a knife crime, you don't want to wait 3 years, 4 years for that trial to come on. But it's also the case that the work that I did in the Lammy review on disproportionality is of course important. It did underpin our understanding of the jury system, and I did focus a lot on accountability and, if you like, sunlight being the best disinfectant. And in relation to that, it's important to recognise that judges now will be given their reasoning, that we are putting in place the transcripts and the transcribe system, because we've got the digital technology that we did not see in the Lammy review, that our magistrates' courts will now have recordings. You will know what the magistrate said, so that you can appeal it if you ever find yourself back at the bar. So for all of those reasons, accountability and transparency was the underpinning of understanding how things are disproportional, and as I say, sunlight being the best disinfectant.
Thank you. And the last question I had kind of builds on that, and it relates to the judiciary, because obviously it's not just about magistrates' court here, and a slightly kind of related issue, but as we know, the High Court judiciary is not representative of the British population, and I just wondered what, if any, additional pressure you can bring to bear on the judiciary to make sure it's fit for the 21st century, so that we have a greater reflection of British people within our High Courts.
We have got greater representation of ethnic minority amongst our magistrates since I did my review, 31% in London. We have got greater representation amongst our court judges, up from 6% to 11% since I did my review, and 21% amongst new entrants into the judiciary, which is a trend that is good, if you like, into the middle ranks and upwards in the years ahead. It is important to emphasise this because some people have not fully understood my review. When I was commissioned to do the review, I was asked to look at whether juries were fair, because some people had concerns that if you had an all-white jury, it was unfair. I asked Professor Cheryl-Thomas to look at this, and she concluded that juries are fair precisely because the 12 people, whatever their background, makes the system very fair and accountable. We did not find that there was disparity between judges, magistrates and a jury, however. Some people have then gone on to conclude that That is not what we found. There was some evidence at the sentencing point, but who recognises that judges sentence after the jury trial anyway. So I just want to make that clear to the system.
Thank you.
We're going to move on to another topic, but just before we leave juries entirely, but you in your last answer there, do you accept that a judge sitting alone without magistrates, which as you say there is diversity amongst magistrates, a judge sitting alone is no less likely to discriminate than a judge sitting with a jury? Is that your evidence?
What I'm suggesting is that in the Lammy review, I looked at juries and gave them a clean bill of health. I looked at sentencing and I did find disproportionality at the point of sentencing. I did not find disproportionality between a magistrate and a jury. That is different in terms of determination.
You're not worried at all about a judge sitting on their own without magistrates or a jury sentencing to somebody to 3 years, or you must be more
in balancing victims of crime, and I've given you the statistics affecting black, Asian and minority ethnic people, and balancing the sorts of crimes that will be in front of the Crown Court bench division and more serious crimes, I've come out at that 18 to 3 year threshold. That's where I've come out, and I do believe that that's the right balance. The data will all be available to scrutinise. The decision-making of our judiciary will be available to... In the end, you don't have a decision or much of a decision from a judge at the moment. You will have that decision as a result of the system that we are introducing, and I think that will allow to better accountability.
You accept that the higher ranks of judiciary, I think we have no one from an ethnic minority in the Supreme Court. This is a matter we discussed with the Lady Chief Justice 2 or 3 weeks ago. One, Lord Justice Singh, I think, in the Court of Appeal, and there is no other person from an ethnic minority.
I do accept, of course, that as you go up the system, there is work to do, and that is where we will be appointing a new chair of the Judicial Appointments Commission in the coming months, and that is still a job in hand, absolutely. But of course, I know that the chair will understand that the reforms that we are making do not pertain to the very highest courts in the land.
If I could sum up that part of the session, I think we would probably say the jury's out, and we are looking forward to having a lot more data to see what the effect will be, both on jury trials and on the backlog. But the one area we haven't covered is what the effect will be on the prison population. And are you going to publish data on that as well? We know what the court review says, or the sentencing bill says, in relation to accommodating, if I could put it that way, a growing prison population. If, as seems inevitable, the consequences of Leveson are more people going to prison because you have magistrates sentencing up to 24 months and you have swift justice, which presumably means people are going to get custodial sentences more quickly, then prisons are going to be overflowing again, aren't they?
I don't think that's quite axiomatic, because that suggests that there'll be a different rate of conviction, and I'd want to maintain that our criminal justice system is fair fundamentally, or it's not much of a criminal justice system. So I'm afraid I can't concede that somehow there'll be a higher conviction rate because you've changed jurisdiction. What we've been focused on is the swift nature of that justice. But as I've said, of course, the modelling that sits behind it will be available to the committee.
Well, it's not. I don't ask you to take responsibility for the last government, but it was an administrative rather than political decision